Hello friends. Today let me discuss about a recent case law which has been delivered on 2nd April 2018. This is relating to a petition filed by a member of the society for paying 5% of the sale consideration as the admission fee to the society. A society in South Mumbai, CHS Park Co-operative Society, by a resolution dated 1993, had recovered 5% of the sale proceeds as the admission fee. The member paid the fees and got the admission to the society, and in the year 1999 he realized that having paid 15,75,000 as the admission fee is an exorbitant fee and it is not provided in anywhere in the law except the resolutions of the society. He challenged this resolution in the year 1999 in the Co-operative Court. So having challenged in the Co-operative Court, they have deliberated, and at the end of the day the Co-operative Court was pleased to pass an order stating that this demand of 15,75,000 as an admission fee is illegal and that need to be refunded forthwith. And the demand by the member was he should be paid along with the interest of 18%, and the Co-operative Court permitted for payment of interest up to 6%. Now the society did not keep quiet. The society did appeal before the Maharashtra Co-operative Appellate Court, where after the arguments it has been held that the decision taken by the cooperatives is within the act and therefore the demand of 5% of the consideration is illegal. The concerned society, CHS Park Co-operative Society, did not leave the matter then. They filed an appeal in the year 2008, the writ petition in the form of writ petition before the Honorable High Court, Mumbai. The writ petition number is 1374 of 2008. After 10 years battle, on 2nd April 2008, Justice Gupte was pleased to say that this demand which has been made is completely illegal and therefore the society need to refund entire money as per the order of the Co-operative Court along with interest of 6%. Now the question arises, what are the plea which has been put by the petitioner when it was challenged before the Honorable High Court? They had raised three major issues. The first issue which was raised and stated that the section 92 of the Co-operative Society Act talks about law of limitation, which is any money which is paid, if it is not claimed within 3 years, the law of limitation of Act 1963 is applicable, and therefore it is the petition is filed after 6 years, and therefore 1993 payment was made. In 1999 petition has been filed by the applicant and therefore or the member of the society for refund, and therefore it is covered under the law of limitation and therefore the plea should be dismissed. The Honorable High Court held that this is not covered. The law of limitation is applicable only after the demise of the member and he is being a member, and section 91 where the 92 is talking about law of limitation and it is against the member, and therefore the law of limitation, the plea raised is not applicable. Any dispute within the member can be raised any time during the membership term and therefore it does not fall within the law of limitation. The second plea which has been raised is about the member has paid this money voluntarily and therefore willingly he has paid, and when it is been paid willingly, so therefore that cannot be demanded, and it is the money which has been paid used for the welfare of the members and in which he is also a member, and therefore this cannot be considered for the refund. The Honorable High Court ruled that this is the payment which has been made as per the resolution, and therefore even if it has been paid willingly, it is something which is not within the purview of the law, which cannot be demanded, and therefore this cannot be considered as the valid ground for not granting the refund. the law should provide, the MCS Act should provide to make this type of provision. Section 23 subsection 1 of the Maharashtra Co-operative Society Act talks about open membership, and when we are talking about open membership, there is no such condition which is put in the act which can restrict or give any power to the society to levy this type of charges. Except admission fee and transfer fee, there is cannot be anything else which can be considered as an admission fee relevant to the what is known as the 5% of the consideration cost. The admission fee earlier in the bylaw it was 1 rupees, now in the model bylaws it is 100 rupees. So this type of 5% is outside the purview of the act, and therefore this is not legal. Thirdly, which has been taken by the society before the Honorable High Court, is that this payment has been made by the transferor, that is the seller, and therefore this payment cannot be refunded to the purchaser who is already a member of the society. The Honorable High Court said, yes, though it has been paid by the seller, he has paid as per the agreement terms on behalf of the purchaser to make him as a member of the society, and having paid on behalf of a member, and it is the identity of the person on whose behalf the payment has been made is important, and not the who has made the payment, and therefore this should be refunded. So with all this, the Honorable High Court has held categorically that no type of admission fee can be taken. There was a similar case which has been relied upon by the Honorable Council on behalf of the petitioner society before the Honorable High Court of an earlier case. What is that case? In that particular case, the Co-operative Court has held that if any money has been voluntarily paid by the member and in the form of a donation, then after paying the money voluntarily, then one cannot take the refund. The name of the case is the Bharatiya Bhavan Co-operative Housing Society Limited versus Krishna H. Bajaj. In that case, the member had paid a voluntary donation, there was a letter to that effect, and therefore the member after paying voluntarily cannot claim the refund. And in the present case, it was not a voluntary payment, it is the compulsion made by passing a resolution. Without payment they would not have made the member, and therefore this is out of the resolution, there it was by voluntary. So therefore the Honorable High Court said the case and the facts are not identical, and therefore one cannot rely on that case. And at the end, the court has held, Honorable High Court has held, that this type of money cannot be recovered, they are illegal. Now what is the guideline for the housing society? I would suggest that the housing society should work within the purview of the Act, rules and bylaws, and there is a circular or the government resolution dated 9th August 2001 which says the transfer fee not exceeding 25,000 should be charged for the transfer of the flat, and this resolution or rather this GR has never been challenged before any court, and therefore today this government resolution is valid, and any direction given under section 79A is binding on the society, and therefore society should not collect more than 25,000 as a transfer fee. As far as admission fee is concerned, yes, it is only 100 rupees which can be collected, and at the most society can collect 500 rupees as a transfer fee for the transfer of the flat, and 25,000 is collected in the form of transfer premium. These are the three things which can be collected. Anything other than this, I personally feel the society should not collect. If at all you need more money, naturally you can charge everybody according to the area of the flat, if it is for major repairs or for the building and the land expenses, and if it is for the common expenses like electricity and maintenance of other buildings, common services, in that case you can charge equally to all the members. Just because somebody is selling the flat and making money or getting some capital gain or the receipts, one should not be put into a jeopardized position, should not be put in the harsh position. The society should be very categorically should not collect more than 25,000 as the transfer fees and the transfer premium. Thank you very much. I hope this video has helped keeping you at great extent. We will come out with more and more of this type of videos, and I request you, if you have any queries, do send us the queries in our website or to our email. And if you want to send it to my personal email also, you can send to my personal email, which is rsprabhu13@gmail.com, and you can contact our office for more details. The phone numbers are written there, address is written there, and the phone number is 022 4255 1414 or 022 4255 1425. Let me tell you, in case your society is looking for some services, anybody is looking for services, Maharashtra Society Welfare Association has appointed area-wise MahaSeWaks. You can contact our office, get the connectivity of the MahaSeWaks. You can invite them to your society and have a detailed discussion, and we can also resolve your society issues. Thank you very much.